first of all, to the Counter Extremism Project, to Hans for the kind introduction, and Sofia for the invitation to be in conversation today. I think before starting, I would like to just center us in the fact that the conversation comes at a very critical moment in time, in which, as Sofia already mentioned, several prosecutions have already been concluded in Germany, but also other European countries, and others are in the pipeline. And notably, as of mid this year, we have a decision by the Grand Chamber of the European Court of Human Rights in a case called HF versus France. And that case, for the first time, outlines very specific human rights obligation to Council of Europe member states with respect to their nationals in camps in northern Syria or northeastern Syria. As part of these obligations, as a result, we will likely see an increase and a timely increase of returns and then cases against returnees. I think the conversation also highlights the importance of exchanging across disciplines, but also across borders. And the questions so far have been really fascinating, I think, so I'm excited for all those that will pop in as time goes along. But I just like to note that if we speak about really looking at different perpetrator groups, but also at different groups that have been affected, a gender competent analysis requires us to look at the gender composition of the perpetrator groups, but also of the affected communities. So in order to understand it, gender competent analysis requires to look at us both ways and also look at grounds beyond gender, such as age, nationality, sexual orientation, and gender identity. What I come to speak about today, however, is my intervention that will outline the importance of investigating and prosecuting harms committed by ISIL or Daesh, both under international criminal law and domestic counterterrorism frameworks. I do so by speaking from the position of a practitioner in Germany. So I will reference some German examples. And I also speak with the recognition that efforts need to be made beyond law and beyond foreign policy to address the physical, psychological, social, and economic matters of persons that have been harmed by ISIL or Daesh crimes, but also those that have returned, most notably children. And this already came up in the question, so perhaps we can dive into this further. My first thesis today is that international criminal law is the legal framework that truly outlaws mass violence. So, albeit, as Sofia mentioned, charges were initially brought specifically against women that have returned from ISIL and from northern Syria and Iraq under the domestic counterterrorism framework. And that may have once upon a time be a very convenient and also practical option for prosecutors to achieve easy and successful prosecutions. I argued that we need international criminal law because international criminal law is really the framework that outlaws harms against persons in their collectivity. And what do I mean by that? So all core international crimes protect persons in their collectivity. For example, looking at the crime of genocide, the collective groups that are being protected are the national, religious, ethnic, and racial groups. If we move on to crimes against humanity, it is really the civilian population that is being protected. And it is civilians, the wounded, the shipwrecked, and those that have laid down arms that are to various degrees protected from harm by war crimes. So moving on to the next slide, please. I'd like to refer to the work of Patricia Visser-Sellers. She's currently serving as the Special Advisor to Slavery Crimes at the Office of the Prosecutor of the International Criminal Court. And she makes a really strong case as to why the counterterrorism framework may not be enough if we really look at harms that are outlawed by international criminal law and what they add to the mix. And that is really the harm to the collectivity that international criminal law endeavors to protect, she says. And that the collective protection is really the doctrinal spinal cord of international criminal law. And it follows in our understanding that although international criminal law is primarily and doctrinally concerned with the groups it protects, and I just mentioned the ones that it does protect, We also need to note that there are subgroups of such protected groups that have different experiences of harm and violence that need to be equally seen and accounted for. So for example, there were lots of questions about children, right? We hear a lot, and I go into examples later, about the different experience of Yazidi women and girls, but what happens to the boys? And to what extent do we have an equal understanding of that? Do we also know what happens to LGBTIQ persons and communities that are also part of the religious minority that ISIL is attacking? And so in closing, SELS critically underlines that international criminal law requires doctrinally for the subgroups to be per se included in the collective protection, and that also they cannot be excluded from that protection in any way. It follows that international criminal law is the legal framework that examines actors as parties to armed conflict, and in that case, Daesh or ISIL as parties to armed conflicts in Iraq and Syria, Daesh or ISIL as actors that commit widespread and systematic attacks against civilian population, and also as actors that have the intent, in whole or in part, to destroy certain groups. Next slide, please. We also know that in May 2020, the EU Genocide Network, which some of you may know, but for those who don't, it's a network of national investigators and prosecutors who operate in the European Union at large. And they meet on a regular basis to address issues that are important to them, but also to foster exchange among the units and among the personnel of those units. And in May 2020, the EU Genocide Network underlined the importance of cumulative charging, so using both legal frameworks at the same time to respond to illegal conduct committed by foreign terrorist fighters, and that cumulative charging needs to occur both under domestic counterterrorism frameworks, but also under international criminal law. It was highlighted in the report, but also during the meeting, that prosecutors at the time in Germany, France, Hungary, Finland, and the Netherlands have had ongoing cases against foreign terrorist fighters, or even judgments that contain cumulative charges. And many of these foreign terrorist fighters had links with member states through either nationality or residencies, where others entered the territory as refugees or asylum seekers. And here I would just like to add a comment, that's not on my slide, but also in response to some of the questions, because interestingly, in the Taha al-J case in Germany, which was a case conducted by the Higher Regional Court in Frankfurt, and that resulted in a successful conviction of genocide, crimes against humanity, and war crimes, there's a little tiny weeny sentence in the press release of the Higher Regional Court that says that actually the charges under the domestic counterterrorism framework were dropped in the case in the final verdict. So perhaps we want to discuss this as well as a new development. Moving on to my second thesis, which is, it is really international crimes that demands us to ask and understand how subgroups of protected groups under international law have been harmed, but also why they have been harmed. And specifically, it's important to look at the relationship between ideologies of ISIL or Daesh and their manifestations as structural drivers of violence that amount to international crimes. So counterterrorism is, among others, and I don't have to mention this here, but I just want to underline it for completeness sake, concerned with ideologies. So among ISIL, there's a strong and effectively documented body of evidence of both religious but also gender ideology that forms the backbone of the terrorist organization. On the other hand, international criminal law complementary investigates how these ideologies relate to structural drivers of mass violence and how these ideologies support systems of violence that manifest. For example, it is specifically in the ISIL or Daesh context, the system established to commit the crime of the slave trade and enslavement as two distinct but interrelated crimes that are a manifestation of the religious but also gender ideology of ISIL and Daesh. In practice, this means that aside from adult men that in the majority have been killed, adult women and children of all genders were enslaved, although the harm experienced in these contexts of their enslavement looks different. So we have a gender and age segregated evidence about the crime of the slave trade and slavery with a religious persecuted group, that is the Yazidi. So for example, women and girls, as we heard, were enslaved for domestic servitude, and depending on their age would experience different forms of sexual crimes, including but not limited to rape, as well as torture, as well as deprivation of liberty, and in some cases, as demonstrated by the Jennifer W. and Taha Al-J case, also murder. However, and I mentioned this earlier, we hear very much less about boy children that were also enslaved, tortured, sexually abused, deprived of their liberty in the context of their forced conscription. So hence the development in the German cases towards a more nuanced understanding of crimes against humanity next to war crimes and genocide is critical. It is the core international crime, and here I mean crimes against humanity, that can make the most direct link to the ideology of the terrorist organization, thus connecting the ideologies with an array of harms that such ideology may cause. So in particular, I like to focus our attention to the crime against humanity of persecution. Persecution, for those who are unfamiliar, is an underlying act of crimes against humanity. And it means that the intentional and severe deprivation of fundamental rights contrary to international law by reasons of the identity of the group or the collectivity on political, racial, national, ethnic, cultural, religious, or gender grounds or any other grounds that are universally recognized as impermissible under international law. So notably, it also needs to be in connection with any act under crimes against humanity, genocide, or war crime. So it cannot be committed by its own, right? And persecution is really the angle for lawyers to say a certain crime, international crime, has been committed and there was a persecutory kind of framework to it, right? It has been committed in a discriminatory fashion, and some also relate to a persecutory conduct as kind of like the initial stages and interrelated conduct to what later constitutes genocide. And if we look at some of the German cases in a concrete example, we can look at the Sarah O case. That was a case in front of the Higher Regional Court of Düsseldorf. And it was very critical in that case that there was a successful conviction and the worldwide first ever to say so, that recognized that persecution has been committed against the Yazidi on intersecting grounds of both religion and gender. Moving on to my third thesis, which is that we need international criminal law to support the creation of a nuanced historical truth for affected survivors and communities. And we also need international criminal law to allow their effective participation in justice processes that concern harms committed against their very own community. And I'd like us to reflect on this thesis by referring to two quotes by Justice Robert Jackson from his opening remarks at the Nuremberg trials. The first quote would be that he opened by saying that the wrongs which we seek to condemn and punish have been so calculated, so malignant, and so devastating that civilization cannot tolerate their being ignored because it cannot survive their being repeated. He goes on further to say that civilization can afford no compromise with the social forces which would gain renewed strength if we deal ambiguously or indecisively with the persons in whom these forces now precariously survive. So he really speaks to not only the importance of persecution by any means, but to not go about this ambiguously or indecisively. So I argue that we can only gain a version of a nuanced historical truth if we investigate the context in which the outlawed conduct was being committed. And the context in this case would be the intent to destroy in whole or in part a religious group, an ethnic group, systematic and widespread attacks against the civilian population, and also crimes outlawed by international law that have been committed in the context of an armed conflict. International criminal law is also a vehicle for all of us to speak to our contemporary but also historical responsibility for the occurrence, but also future prevention of international crimes. I argue that returned persons involved in ISO crimes solely prosecuted under counterterrorism frameworks constitute actually an obstacle for a nuanced historical truth of what has happened against whom, by whom, and why. And another barrier to a nuanced historical truth are gender stereotypes, and we already touched upon this, that are at play when evaluating involvement of women in ISO crimes. And for reference, there's an article written by Carlotta Salah, Niriksha Sangvi, and myself on the topic, and we really examined by looking at prosecutions that have been concluded in Germany, what are some of the gender stereotypes, but also bordering racial stereotypes at play when looking at the responsibility of women in ISO crimes. To that extent, and this question has already been posed, why is it that only women but not men have been prosecuted for the war crimes of pillage when men have been living in the very same houses as well? And why is it that only women but not men are prosecuted, albeit not as an international crime, for the violation of the duty of care of children? And how much of this is a reproduction of the very same gender ideology that are actually in-housed by ISIL or Daesh, right? And how much more deconstruction work do we need to be doing? And I like to close with one recognition and one wish. The recognition being really the work of civil society organization, often also civil society organization from the community that have experienced the harm. So Yazidi-led civil society organizations that have been detrimental in identifying key witnesses that served in several of the trials that led to successful prosecutions in Germany, that have provided additional evidence to the prosecution authorities, and that not always receive the kind of praise that they should. At the same time, the praise of psychosocial support organization in Germany, and probably also other contexts, but I'm more familiar with the German context. But also to say that more needs to be done, because these organizations, they rely on public funding, and there's a massive backlog of thousands of individuals in Germany who would like to be supported, some of them as part of these trials and investigations, but also others that would just like to have treatment and support in working with the trauma and physical and psychological manifestations of the violence they have experienced. And lastly, my wish would be to really enhance public debate and multidisciplinary conversations on the issues, because as we know, this issue is so multi-layered in nature, and also our collective responsibility to respond and establish resources for justice, but also other questions at play is really called here. So for example, what are the physical, psychological, and socioeconomic and community healing needs of those that survived ISIL or Daesh crimes? And what drove underage persons from Germany, but also other European states, to join ISIL or Daesh? And what are the meaningful harm-reducing responses to their return, acknowledging that survivors live in their proximity? And it's great NGOs step in, but what is the state responsibility to jump in these responses in a most effective way? Thank you so much for your attention. I look forward to any questions you may have.